June had asked me to speak on numerous different subjects. One of them that she didn't ask me to speak on was Medicaid. But I included a lot of information about Medicaid at the end. I am not an expert on Medicaid. And, actually, frankly, Chris, the other attorney at the firm, has a lot more experience in Medicaid than I do. But I know enough about it to essentially explain some things to you, which is, number one, Medicaid is not the free ride it's presented to be. That's probably the simplest way I could explain it. And when we get to that point, we can talk about that a little bit. So once again, just to get started, the first part of the presentation, you'll see a little cartoon. It may or may not be readable, but essentially it's intended to show you and to depict that when you don't get things resolved when you have a chance to, you can potentially create family feuds down the road. And the last thing you want to have happen when you pass away, it's already a traumatic time for people to deal with. The last thing you want to have happen is create a family feud. Now, I know a lot about that from a legal experience. I also know a lot about that from a personal experience. My father passed away about 6 or 7 years ago now. And even though there were 3 attorneys in the family, he didn't have a will or estate plan or anything of the sort. And he passed away, unfortunately, up in Ohio. So I'm not an Ohio lawyer, but it wound up creating a fairly sizable mess. I use his example a lot because he almost fell into every single trap you could fall into as far as making a mess. He had divorced my mom in about, I think it was 1989. And that wound up being a very important date because there's a statute in Ohio and a similar statute in South Carolina that prohibits ex-spouses from inheriting. It went into effect in 1990. He hadn't updated any of his beneficiary information. So a lot of his funds were actually going to my mom, which would have been fine, except for the fact that he passed away with a bunch of creditors. So if those funds didn't go to my mom, they were going to go to, American Express, AT&T, and all these wonderful creditors that we all want to pay off so dearly, but frankly, when you passed away, most of us don't care about them anymore. So that immediately created a complication in his estate. Furthermore, he didn't identify, did he want me or my sister to be up in Ohio? It's called the executor. Down here, it's the personal representative. Since nobody was appointed, somebody would have to be appointed by the court. Because he didn't have a will, this was probably the most ridiculous thing up in Ohio. It is similar down here, although I will tell you the Greenville County courts, we have a lot of familiarity with the judges down there. They do tend to take a much more pragmatic approach to things than Ohio. But because he didn't have a will, my uncle, who wound up being the PR, had to post bond, which my sister and I thought was a bit ridiculous since we were the only potential beneficiaries. And we didn't ask for bond to be posted because outside of his retirement accounts, he had no assets, which was the issue with the creditors to begin with. But essentially, it winds up potentially causing family members a great deal of headache and potentially costing them a great deal of money when you don't plan properly ahead of time. At the end of the day, I always tell people this, though. I mean, the headache that you have when you haven't planned your will and properly and your estate properly is really not your headache. Frankly, you're gone. It's your beneficiary's headache. It's potentially your husband's headache. It's potentially your wife's headache. One thing to keep in mind in South Carolina, a lot of people, when they don't have a will, think, well, who cares? My husband will just automatically, he'll be the PR. He'll take care of everything. Well, that's not how it works if you have kids in South Carolina. Your kids will wind up having the same standing as your husband or your wife, your spouse. Your kids will wind up having the same standing as your spouse. And if there's a dispute among them as to who should take care of things, that can immediately cause some legal problems and expenses. Furthermore, one of the most common problems you see in South Carolina when you don't have a will, and I would say this is the most common. Many people that don't have a will think to themselves, well, I have I don't have a very large estate. I have an estate that's maybe $300,000 or less, or maybe even less than that. And what I do have is in my retirement account. And my retirement account is not going to go through probate because I have been diligent and I have made sure that I have beneficiary designations. Okay? Well, so far, so good. You don't have a large estate. You've determined who your beneficiaries are going to be. And if you truly did die, essentially without any assets, it's not that difficult to go through an intestacy probate. It's not, I don't want to pretend like it's the end of the world if you don't have any assets. But at the same time, there's usually a problem people run into in South Carolina, and that's with their house. A lot of times, people will have their house titled in what I'm going to refer to as tenants in common. And let's say you're married. Your husband would own half, and you would own half. If you die intestate without a will, then what would happen in that situation is that one half of the real property you own, half of a half, or a quarter, what winds up being a quarter of the real property, now is transferred to your husband. But the other half of the half, or the other quarter, winds up going to your kids. And if you have more than one kid, you can wind up having about 5 or 6 people now on this deed. And a lot of times people say, well, my kids will work it out. Yes and no. It depends on, it really does depend on the value. Let's say you have one family member who's struggling. You have one child who's struggling. He or she's got a couple kids. Mom and dad didn't have a big estate. They know mom and dad don't have a big estate. Mom dies. Let's say the house is worth $500,000. Maybe he's only inheriting an eighth of a house. But that could be a lot of money to some people. $50,000, $60,000, that's a lot of money to me. $50,000, $60,000 can be quite a big deal of money. And they may not be willing to walk away from it. And they can justify it by saying, look, I'm doing this for my children, for the grandchildren. Also, something else to keep in mind that's very important. God forbid you have a child or a potential beneficiary who's incapacitated. And let's pretend there was not a conservator or guardian set up, let's pretend there is a conservator and a guardian set up for that child. Well, you've not done a good estate plan. And in your heart, well, my child would disinherit that. Perhaps he or she would. But once that child's adjudicated as incapacitated, his appointed representative, the appointed conservator / an appointed guardian, particularly the conservator is not going to be allowed to disinherit. The conservator has to act in the financial best interest of his client, which is your child in that situation. So I've just given you this hypothetical where the child's coming into $50,000. Mom didn't do an estate plan. But now the child's supposed to, we can clean it up if the child will just disinherit it. But the conservator comes to me and says, I can't disinherit it because I have a fiduciary duty to the child. That's not a made-up fact scenario. That's a real fact scenario that I've had. So that's not an imaginary fact scenario. What happened in this situation is mom didn't get her will in place. The husband may have even had his will in place. I can't remember. The father may have even had his will in place. But mom didn't get the will in place. They had the house set up as tenants in common. She was in an accident with her child. So you might say, well, how could the child be incapacitated before me? Well, they were in an accident together. The child truly was incapacitated. In this scenario, there was only one child. And he was going to inherit a quarter of about a $600,000 house. And so what wound up happening is essentially dad had to find a way to buy him out. But dad was, it was very difficult because the father was in his late 70s. So it wasn't an easy situation. Funds had to be moved around to essentially buy out the son in this situation. That is a scenario which comes up frequently. Not always that big, not always that big of a value in the house, but a situation where we didn't plan for what we're going to do with the real property. And again, I would say for I'm making up statistics to a degree, but from what I've seen in my experience, probably about 60 to 70% of the people are not looking at they're not looking at huge estates that come into our office. They're looking at estates where they have real property exposure, and that is the number one reason they need a will, to figure out who's going to inherit after they die. The other solution to that is fairly simple. When you're married, I generally encourage people to hold their property in what's called joint tenants with right of survivorship. In other words, if you're married and you own real property, particularly if it's your personal residence, there may be, if it's commercial property or if it's investment property, there's a different analysis that needs to take place. But if it's your personal residence and you're married, I would encourage you to consider joint tenants with the right of survivorship. The problem is in South Carolina, a lot of the real estate attorneys don't bring that up to you at the very beginning. There's a reason why. When I started my practice in 2008, I did a lot of residential closings. And I always wondered why did we not bring up joint tenants right of survivorship? Then I started to learn why. The forms as they came to us on the SoftPro software always defaulted to tenants in common. Because remember, if you're owning property with your friend, if you're buying a piece of property with your friend and you're not married, you wouldn't want to default to tenants in common. You can set up joint right of survivorship with your friends also, but then basically you're creating a situation where you pass away and now your friend and eventually your friend's family inherits half of real property that you were potentially using as an investment. So that doesn't make sense. So the forms are set up as tenants in common. That may have changed. I don't think it has. And again, most attorneys don't bring up joint tenants with right of survivorship. There's another. If you own a business, if you own a small business, sometimes it will behoove you to title all the property in the party's name who doesn't own the business. That way you can separate the assets in the event the business is ever sued. In other words, an event that anyone's ever able to do what's called pierce the corporate veil and get to the individual. If all the assets are owned by the non-business owner, it makes it easier to protect them. But most people don't own a small business. Most people don't need to do that analysis. Most people should have it set up in joint tenants with right of survivorship. And frankly, even if you own a small business, you need to take a pause before you don't set it up as joint tenants with right of survivorship. So I think what we've done is I've at least presented to you the reasons you need a will. Let's talk about planning your estate. If you'll see it's actually only on the first slide. One of the things we want to do, determine the value of your assets and your debts. Go ahead.
Before you read that study, I want to ask you a question. Do you have to have a family member to put you up with?
No. And we'll talk about that in a little bit.
Do you want to repeat the question and then I'll
Sure.
do our work next time?
Sure. The question was, and if you give me 1 second, I want to, just so I'm keeping track of time here. So I know I don't want to run out.
So you don't have to.
Sure. The question was, do you have to have your family member be a personal representative? The answer to that question is a very definitive no. Do I usually encourage you to have a family member? Usually. I mean, again, it depends on the situation. If you have a family member you can trust to be your personal representative, you should name them as the personal representative. Usually family members, not always, are going to, they're not interested in charging anything. They don't want to make any money off of the situation for being your PR. If you go hire a professional to be your PR, they're going to charge a fee. They're going to want to make sure they're being paid a fee. By the way, just because I name you as my PR doesn't mean you're condemned to accept it. I mean, I could theoretically name Donald Trump, president, as my personal representative. That doesn't mean he's going to, Brian, I'll take care of your estate. No. Just because you're named to be the personal representative, it's basically we're asking you to be the personal representative. And one thing we advise people before you name anybody to be your personal representative is make sure you've talked to them. You say, hey, I'm thinking about naming you. Is this a responsibility you'd want to undertake? It's not a responsibility anybody really should want to undertake. It's not fun. It's not rewarding. It can be complicated, and particularly when, like, let's say we have the hypothetical where you pass away and there are no liquid assets in the estate. And by the way, a good attorney is going to try to create a situation where there are no liquid assets in the estate, because there's no reason to have liquid assets in the estate. But let's say that does occur. Well, the only property that's flowing through the estate is the real property. How are we paying for the attorney's fees? And if you want somebody like us to administer the estate, somebody has to front the money for the attorney's fees. Now, generally what will happen in that situation is essentially a lot of times the real property needs to be sold. Most of the times people don't pass away with it perfect, particularly these days. Very few people I've seen passing away with a house paid off. And most of the times that just doesn't happen anymore. I mean, my mom's 70 and she refinanced her house like 2 or 3 years ago while she was still working. So, she's got a 30-year mortgage. That's not getting paid off. I mean, I guess it's possible, but I'm not anticipating that's getting paid off. So a lot of times what we're doing when you pass away is we're just trying to hold on to the house long enough to sell the house. And then what will happen is the PR will get reimbursed for any expenses he or she paid during the pendency of the sale. But the short answer to your question is no. You don't have to have a relative as your PR. So a lot of these, since we are running a little short on time, a lot of these slides you can read for yourself. I don't want to walk through every little bit and piece of the slide. Bottom line is find out what you own. What I tell people is, ideally we don't have 15 different bank accounts. It's okay if you do. It's not the end of the world, and there are reasons to have different bank accounts. But ideally we have things as we're getting a little bit older, consolidated to an extent. The theory is you shouldn't have more than $250,000 in any one account, because that's not FDIC insured after that. But again, if you're having that problem, good. But you want to try to consolidate things so that we're not dealing with 15 or 20 different accounts. Most important thing that I consider you can do even before you get legal advice, or at least while you're obtaining the legal advice, is jot down, whether it's in computer form or handwritten form, these are my assets. These are my passwords. And if I have it online, these are my passwords. These are my life insurance policies. It may surprise you, but a lot of times life insurance policies don't just reach out to you and try to find who the beneficiary is. They they're supposed to do a cursory search, but if you don't claim it, the money can wind up going to the state. I mean, if nobody knows we have a policy, that's not helpful. So define the policies. Let us know your bank accounts. Let us know what real property you have. I had this problem just a few months ago. Somebody came in and their mom had passed away, and we had no idea what timeshares they owned. People forget about timeshares. I mean, those are assets as well. We need to know what they are. How are we going to handle these? So, know what you own. And then if you look at the slide, assets to consider: checking account, savings account, money owed to you. This is on page 2. Stocks, bonds, and mutual funds, business interests, professional practice, real estate holdings. Money owed to you. What do I mean by that? Let's say mom had a promissory note in place, and this comes up quite a bit. Let's say there was a note in place where a family member had borrowed $50,000 from mom and was supposed to be paying that back. And we actually have documentation. It's not one of these sort of handshake gifts. We actually have documentation of the note. That can be important for the other beneficiaries in the family. Look, Susie, you still owe mom $50,000, so that bill's still going to have to be paid. Other assets to consider: your life insurance, your retirement plans, deferred comp plans, household contents, vehicles, boats, jewelry, fine art items, antiques, and collectibles. Let me talk a little bit about the jewelry and about the household items, is what I'm going to call it. If you have a jewelry collection, something that's very valuable, that's what you need. That's what I'm talking about as far as considering it. One of the things I've noted over the years is when you pass away and we fill out the forms for probate, generally we put down maybe $500 or $1,000 for household furnishings, with rare exception, and that's never really been challenged. You'll find that, at least I found this firsthand. I mean, everybody thinks all the household furnishings they have in their house are worth $20,000, $30,000. You might have paid $20,000 or $30,000 to get them, but when you actually try to sell them at a garage sale, a lot of times, unless you're an antique collector, unless you've really cherished them and kept them up as antiques, you're not getting anything for them of any real merit. I'm going to turn the page. This is page 4. I'm going to talk about the basic estate plan. This is what 90%, in my opinion, maybe 80%, maybe it's a little different, of the people generally need. Real quick, this is a little off topic, but one thing that I need to discuss with you is South Carolina has no state estate tax. Ohio does, and it's pretty low threshold. It's like $300 and some thousand. South Carolina has no state estate tax. Right now, and it's somewhere in this slide presentation, I think it's on page 8, we don't need to turn there, but right now, essentially, the gift tax, or the exemption right now for estates from the federal estate tax is $5.49 million. And really, for married couples, it's $10.98 million. It doesn't impact a lot of people. And I could give a whole presentation on that, because I was a little bit irritated with what they were trying to do with the law there. They were actually taking away what was called the step-up in basis, which was going to hurt most Americans, in order so they could get rid of the estate tax. They're calling it the death tax. We're going to get rid of it. Well, it doesn't affect us. It affects most of the members of Congress. But the step-up in basis can affect a lot of us. So I always warn people, whenever the government starts talking about giving you a tax break, look for the tax hike. But to make it bottom line short, most of us are not going to be affected by the federal estate tax. And even if you're getting close to that amount, there are things we can do to protect you even further. So the real threshold is pretty high. But so most people in South Carolina, and there are specific exceptions. There are good reasons to get trust. I don't want to turn everybody off on trust, because when you're dealing with Medicaid and we're dealing with special needs, there are good reasons to get a trust. But most people don't just come in needing a trust. In Ohio, most people do come in needing a trust, because remember, when you're calculating your estate, life insurance does come into play, particularly for the federal estate tax. And at least in Ohio, I think it was 1/2 of it came in for the state estate tax. Not an Ohio attorney, can't give comment on it. Again, that was based on real experience. And so I learned from when my dad passed away, it's true what they say. South Carolina is a good place to pass away. It's a friendly place to die. That's why there are a lot of retirees down here. It's a true point. You don't like it?
No exemption.
What's that?
No exemption.
I'm sorry, what do you mean? There's no state estate tax. Yeah, there's no state estate tax here. There is a probate tax that's less than 0.25%. I tell people, let's not lose sleep over that. It's a minuscule tax, and a lot of states will charge you that much just for filing your documents. So it's not anything to lose sleep over. So what's the basic estate plan down in South Carolina? Well, we've talked about the will ad nauseum. Frankly, I told you at the very beginning, the will impacts your beneficiaries. You're gone. The will doesn't really impact you. I mean, you're not here to deal with it. The two documents are of the utmost importance, in my opinion, during your lifetime, are the healthcare power of attorney and the durable power of attorney. Healthcare power of attorney, what does that mean? Well, the healthcare power of attorneys, they call it the healthcare directive, whatever you want to call it. Essentially, it says that if I'm incapacitated, this is the person I choose to make healthcare decisions for me. And again, it doesn't have to be a relative, to your point. A lot of times it is. Sometimes it's not. If you have a friend who's a doctor and he's willing to do it for you, or she's willing to do it for you, that might be a good choice. The durable power of attorney I have listed as financial. Because what does that mean? The durable power of attorney is the person who's going to be handling your finances when you're incapacitated. Boy, you better trust this person. I mean, you don't trust this person, you got a problem. Now, the durable power of attorney is under a fiduciary duty to protect you. But, there's an old, once you've lost the money, once they've squandered the money, if you've picked someone that you shouldn't have and they've liquidated all of your assets, we can sue them for $1 million. It doesn't make any difference if there's nowhere to collect. As a younger attorney, I learned that the hard way. When you're young, you go out and get a whole bunch of verdicts, like, a couple $100,000. You take cases nobody else would take, and you get these great verdicts and default verdicts, and you're like, well, this is wonderful. I'll be able to pay off my student loans, and I'll be set for life. And then you realize, well, even if I have $1 million verdict, if I can't collect it, who cares? Because I'm not going to get paid on a contingency fee. That's why the older you get, the less you take on contingency, particularly when you're dealing with collection situations. Particularly when you're dealing with individual collection situations. But the durable power of attorney deals with your financial aspects. One of the things you got to keep in mind with your durable power of attorney is, a lot of attorneys have different forms. I feel like our form is very comprehensive. You can go online and find a form. You can go to LegalZoom or whatever and find a form. I beg you to read it, if nothing else, at least understand what you're signing. The purpose of an attorney when you're doing these forms is not just to print the form for you, but to actually explain to you what we're doing. There are a couple of key points in durable power of attorneys that can come up. One we just dealt with today. Did the durable power of attorney enable the power of attorney to make decisions concerning trusts? Because we've run into a situation where we do need to set up an income trust for purposes of Medicaid. And it's unclear, based on the way this durable power of attorney was drafted, that the durable power of attorney has that authority. Does he or she have that authority to do that? We're going to obviously take the position that he or she does, but I don't like taking positions. When you're going with Medicaid, you want to take a position. You want to have clear authority. The other issue that comes up quite a bit in these things is gifting authority. Have you granted your agent gifting authority? If you haven't specifically granted your agent gifting authority, he or she can't provide gifts. And let me make it, and there are good reasons not to give gifting authority. It should be common sense, but let's say the durable power of attorney has gifting authority, and hey, well, I'm sure mom would have wanted to give $10,000 to her grandchildren this Christmas. Why not? Maybe not, but maybe she did. Because maybe she's trying to qualify for Medicaid in a few years. Maybe it's not such a bad thing to try to liquidate ourselves of assets. So those are the issues with the durable healthcare power of attorney and the durable power of attorney. The healthcare power of attorney is also referred to as a durable healthcare power of attorney. Go ahead.
You just answered my question, I think. Why is it durable finance?
It's a durable healthcare power of attorney. It is durable. They're both durable. Durable, just right.
Does that mean that you can't durable? Define durable for me. Does that mean you can't change
No.
who that person is? Or?
Here's what it means from a legal perspective. It means it's in place when you're incapacitated. For example, I could give you a limited power of attorney today, but if I become incapacitated, your power of attorney is no longer in place. And the durable the financial durable power of attorney, the durable power of attorney as we call it, which I refer to as the financial one, that's not effective unless it's filed down at the Register of Deeds. So you wind up filing that down at the Register of Deeds, and it'll show up whenever you do a property search. So hopefully does that go ahead.
Does it tend to be that the PR person or PR designated person ends up being this for people? Do they usually fill both roles or no?
You can have one person fill as many roles as you want. It doesn't have to be. I always tell people to pick 3, which sometimes gets a little aggressive, but I always tell people to at least pick 3. Generally, if you're married, you start with your husband or your wife as your number 1. If you have kids, if you can't figure it out, then I usually say go oldest to youngest. I may be biased, I'm the oldest. But I worked for an old attorney in Seneca, South Carolina years ago, and he explained it to me this way, and I liked what he said. He said, I've got a son that's a stockbroker. Now, he makes sense to make him the durable power of attorney. I've got a daughter who's a nurse. Well, it makes sense to make her the healthcare power of attorney. I do want to talk real quickly about what a healthcare power of attorney is not. It's not a living will. Arguably it is, because the form they have now is a little unique, where you almost have a living will built within it, but I don't want to get into that. A living will is when you're stating, if I'm incapacitated, if I'm at a point where I'm going to call it on the machine, tube feeding, I'm brain dead, 2 doctors have said I'm not going to make it, I'm not coming back. A living will says I either want to continue to receive hydration or not. And you make that decision. You don't have to make that decision. You can leave that to your healthcare agent. I beg you not to. I would beg you not to do that, because inevitably there's a dispute in the family. It happened with my grandma. She didn't have a living will. You'll find my family wasn't very good at doing any type of estate planning at all. But my grandma didn't have a living will, so for years my dad killed grandma. It's just, he chose to pull the plug. He did it. Well, make the decision for him. Stand up and say, this is what I want to do, this is what I don't want to do. Sometimes people ask me, well, will I feel pain? When I have no idea. I don't know. I don't know whether you feel anything when you're brain dead or not. I just don't have any clue. I haven't died. I always tell people I haven't died before. So I can't answer that question for you. I will say I don't want to stay alive if I'm in that state. But everybody's got to make that decision for themselves. Whichever way you decide, please just make it for yourself. So then you might say, well, then what's the healthcare power of attorney for? What's the durable healthcare power of attorney for? I give this example because I think it's a good one. Let's say you're in a car accident. You're unconscious. You may be in a coma. You're definitely going to survive. There's no doubt you're going to survive. But the doctor has this brilliant new surgery, and right now you're paralyzed from the waist down. This brilliant new surgery, you're going to be walking around, you're going to be fine. But there's a risk associated with it. If we mess it up, you're going to be paralyzed from the neck down. Well, who makes that decision as to whether or not to go forward with the surgery? It's not you, you're in a coma. So that's the decision of your healthcare power of attorney. That's why in that hypothetical I provided you, where you lived in a perfect world and you had a daughter who was a doctor, a nurse, and a son who was a stockbroker, the daughter is going to listen to the doctor and explain to her brother, hey, look, this is nonsense. This is just the doctor's fine print to get out of any legal liability. This is not a real risk associated with this surgery. Or the doctor's going to say, this guy's a little bit of a kook. We're not going to do that surgery. That's way too high risk. So ideally, in a perfect world, you have somebody who at least has a little bit of a medical background as your healthcare power of attorney, and you have somebody who at least has a little bit of a financial background as your durable power of attorney. More than anything else, make sure you pick somebody you trust. You could have a son as a stockbroker, but if he's fast and loose with other people's money, you don't want him to be your durable power of attorney. You want somebody you can absolutely trust. People come in and do this. This happens a lot, actually, where the youngest child takes you into the attorney's office, and mom and dad decided to leave me in charge of everything, and here they are today, and they want to redo their estate plan. Any good estate attorney, that's an immediate red flag. The child's bringing the couple to the attorney. That's not in and of itself a bad thing. If they just want mom and dad to get an estate plan, that's not a bad thing. I just can get concerned when they tell me mom and dad want to leave me in charge of everything, and then you find out maybe Junior had some problems growing up. This is his big opportunity to be responsible. Don't give Junior his big opportunity to be responsible when you're nearing the end of your life. Everybody knows their kids. Everybody knows their family. By this point, you probably know the people who are most responsible in your life, in your inner circle. Those are the people you want to pick first. Sometimes, once we've gone through the list, it might come down to that last guy or that last lady. That's the way life is. Sometimes if you go through the list, you pick your first choice, your second choice. Sometimes your third choice isn't your favorite choice, but don't at least don't put the last person in the world you'd want to be your PR. Don't put them number one. And I know that sounds facetious, but I assure you it is not. Go ahead.
Is the DNR a part of any of these packages, trust, or?
You talking about do not resuscitate?
Yeah.
I don't have it as part of it. I mean, you can do one if you want. I don't. Somebody brought that up a few years ago, and I got a little bit scared by him because, again, this was a situation where the son was pushing me to do that for his dad. And I was like, well, your dad hasn't really brought it up to me, and I'm a little worried, that you're pushing this thing. So, no, it's not. If you want to do it, that's something we could talk about, but
It's also a physician's order for a DNR. It's not an attorney's order. It's signed by a physician.
right, but I got concerned because he was wanting us to set it up, just can you give us a form for it? It's just strange. It's just strange. We don't do that. That's not part of an estate package. There are other estate planning tools, and we're going to talk about these real quick. We've already talked about some of them. Trust. What's the great advantage? Oh, I'm sorry. Go ahead.
I have a question about I have a considerable amount of stock and bonds and stuff. Don't have many of my children, and that's the reason I asked you about it. Are you saying that I could appoint somebody who did have a knowledge of that stuff, give them what you call a power of attorney?
Well, if you're dealing with considerable assets, you may want to talk to a financial institution and see if they're willing to handle it. Or if you have somebody who is capable of being that responsible and willing to do it, either for free or for a defined fee, you could talk to them. You can appoint whoever you want. I just, it's like buying a car. Let the buyer beware. I mean, if I'm appointing somebody whom I don't have 100% faith in, I don't know what they're going to do with the assets. Now, they're under a fiduciary duty to look out for your best interest. But that's not as great as it sounds. Let's say we have a huge risk taker, or somebody who doesn't always make the best business decisions. Maybe I am looking out for your best interest. I bet it all on AT&T. I thought that stock was going to go through the roof. It crashed. I mean, most normal stockbrokers would diversify it. You could make an argument he didn't look out for your best interest because he wasn't diversifying it, but maybe he could come up with some argument that no, it was. If you looked at it historically, this was a good idea. You need to make sure whoever you're appointing is trustworthy. Realistically, I'm not a stockbroker. So if you appoint me as your durable power of attorney and you have a whole bunch of stocks, what I'm going to do is I'm going to take your stocks and I'm going to put them in a financial institution, and I'm going to have a professional broker manage your stocks. And then I've fulfilled my duty as your durable power of attorney. Now, all I have to do is ensure that I put it in someplace reputable. I don't put it in, Bob's online stock brokerage firm. I put it in someplace that's insured. It's a reputable institution. It doesn't have to be a big institution. It just needs to has a proper insurance. It's set up properly. It's properly licensed. Then I've done my job as the durable power of attorney. So you can name somebody to do that. Again, it depends on how well you trust the person. I don't know who you would name, so you're the one who knows who you trust.
But then you could appoint somebody else, be an executor or a secretary, and to handle the rest of the estate, right?
Well, no, we're getting the two things confused a little bit. We're talking about a durable power of attorney, which is a living document. That's when you're alive. And then we're talking about the executor, which has to deal with the will. When you pass away, the executor comes into play. What you may be referring to in a little bit is, and perhaps referring to some type of trust. Sometimes what people do is they create a trust. And then the trustee manages the funds. And the trustee may still manage those funds after they've passed away, depending on what type of trust is set up. Depending on whether or not it flows to the beneficiaries immediately after the party originated passed away. So in that situation, you could, in theory, have a trustee who's still managing assets that would have been assets of the estate, and an executor who's managing the probate estate. Anything that goes into a trust never goes into the probate estate. So the trust estate is always different than the probate estate. The probate estate only includes those items which don't have beneficiary designations and are not otherwise disposed of through a trust. Does that answer your question, or did I?
I think so.
Okay.
I'll talk with you about it later.
Okay. The bottom line is if you trust people, if you trust the people you've appointed, you can do just about anything. But the most important thing is that you trust them. I shouldn't say you can do anything, but you can appoint anyone, but please trust them. That's all I ask.
What do you do if you've appointed somebody in a will
Uh-huh.
and you decide for that reason that person is in another state that's going to be a problem, and you decide for somebody else? How do you do that?
A lot of times the simplest thing to do is just to redo the will. I mean, you could, in theory, do an amendment to the will, but it's silly because a lot of times it's just as easy to redo the will. Wills don't have to be filed down here ahead of time. Wills generally are not filed till after you pass away, so it's just, it's not, there's no need to do an amendment, and a lot of times it's confusing. It's kind of like people say, well, what do I do if I have a will from another state? Well, I could, in theory, get that will approved by the probate court down here, but that's going to cost you money to begin with. If you passed away, I would certainly try to get that will approved by the probate court down here, but that's going to cost the estate money. A lot of times it's a lot less expensive just to do a new will. Now, people use, what does a will cost? Well, again, you go on LegalZoom, there's a will, this is a will, you can go here, this guy charges X, this guy charges Y. There's no definitive amount that a will costs. I always tell people the more confusing you make your will, it costs more money. You know, so if you come to me and say, I want to leave everything to my wife, and if she's no longer with me, I want to leave everything to my children, well, that's simple. If you come to me and say, well, I want to leave everything, I want to leave the house to my wife and this to my cousin Bob, and et cetera, that's more time consuming. Specific devices create more liability for the attorney, and they take more time. What does a will not pass? Maybe we should talk about that real quick. A will does not pass anything. I think we've already said this. A will does not pass anything that has a beneficiary designation. So we have a beneficiary designation on account. That doesn't pass through the will. If you hold your real property as joint right or survivorship, that's not going to pass through the will. Because remember, in a joint right or survivorship situation, as soon as you pass away, that property goes to the other survivor. So even if you're in your will, you said, I want to leave all my real property to my cousin Bob, it doesn't matter because the property has already been devised to the other owner. Also, real quick, for those of you that were planning on disinheriting your spouse, there is such a thing as the elective share. They're entitled to a third no matter what. There's nothing you can do to disinherit them completely. Having said that, there's no rule that says your will has to be set up where you present at least 1/3. It's just something to keep in mind. If you're going to try to disinherit them, they can fight you on it and they can get up to a third. Where does that really come into play? Well, let's say you were thinking about a divorce, and this does happen. You're thinking about a divorce. Heck, one of you may even be on the way down to the courthouse and something happens. That's when that generally comes into play. It's like, well, I already updated my will because I was thinking about the divorce. Okay, so we've talked about, I think we're running out of time a little bit here. We got about 6 minutes left, so let me just jump up. We've talked about estate planning tools. There are other tools, trusts, gifts, jointly held property. Life insurance can be a form of an estate planning tool, and that might be the way you're planning on paying off debts in the future. Safety deposit boxes. I think what I meant by that was simply, some people, if you have things in a safety deposit box, again, make sure people know where it is. Make sure people know what bank it's at. And that they have a key. One thing I also want to talk about real quick is what's called the memorandum of will. It's the only part of the will that you can change without going back to the attorney. You can scratch up all over it. You can write on it. It's the only part of the will you can do that. I encourage you not to write on it. I encourage you just to create a new one. What is the memorandum of will? The memorandum of will passes non-titled assets. What is that? Well, that baseball cap you're wearing there is a non-titled asset. It's not for cash. It's not for, my bank account. It's not for my boat. A boat's a titled asset. It's not for any of that. But let's say you had a baseball cap collection. I'm just going to use that since he's wearing one. And he wanted to give that baseball cap collection to his cousin George. His kids were getting everything else, but his kids hated baseball. And so he really wants to give his baseball cap collection to his cousin George. He'd write a specific statement in his memorandum of will: my baseball cap collection goes to my cousin George, and you'd initial it and date it. And then when you pass away, in theory, your PR is supposed to read your memorandum of will, and before they start divvying up everything in your house, they should find the baseball cap collection and say it goes to cousin George. What I tell people is, don't take an inventory of your house and try to write everything under the sun down. There are usually only a few items that are truly family heirlooms. That's what the memorandum of will is for. And if you don't have any family heirlooms, don't worry about it, because your PR is going to divide everything. And let's say you said everything goes to my kids equally. Well, in theory, your PR is going to try to divide everything equally among your kids. It's never perfect. The first person to the house usually gets the best dibs on grandma's jewelry. That's just the way it works. And I'm telling you. And people come in sometimes, they want to fight a lawsuit over it. And it's like, well, how much is the jewelry worth? Well, I don't know. It could be worth $1,500. Well, my retainer is going to be $5,000. So you're out. So, I know it hurts people. I know it is unfair. I'm not trying to make little of it. But to engage in litigation is very expensive. You don't want to do it over minor events. Some people say, well, the small claims court. I always tell you, have at it. That's not as easy a remedy as people think. It's very inefficient. You're engaging in a long-term battle with your family. Usually the best advice is try to work it out. Now, when you're dealing with a couple $1 million, you're not going to work it out. And those, we're dealing with one right now where there literally is a $50,000 to $60,000 jewelry collection where there's some fight as to how the PR divided. That's a little bit different. There's a lot of money. But if we're talking about a baseball cap or a mug, let's not go to court over that. And again, I think we're almost to the end, so I wanted to run through the rest of this quickly. Probate, we've talked about probate. What is probate? Which assets are subject to probate? Why avoid probate? The simple reason as to why you avoid probate is because there is a slight probate tax. Also, anything that falls into the probate estate is subject to creditors' claims. So if you have a lot of debts, it's a good idea to avoid probate. Now, keep in mind, most people have a huge debt. It's their house, the mortgage. You're not getting out of your mortgage. I don't care that I put my house in a trust. Well, first of all, your bank's now going to call your loan. As soon as you deeded that house over to the trust, if the bank was paying attention, they called your loan. So now you've created, if you had $150,000 owed on your house, you just created a $150,000 liability. There's a provision in every mortgage that basically prohibits transfers unless they're told about it. Now, it used to be, and I debated some other attorneys who are a little bit older than me about this one. It used to be, they'll never find out. The bank will never find out because they're not going to check the website. They're not going to check, at the time it wasn't a website, they're not going to go to the Register of Deeds and check to see if George did a transfer of his property into trust. They're not going to find out. So just go ahead and take a chance. Nowadays, it's not true. Nowadays, it's absolutely not true. Everything's online. You got big banks, they just have programs that search the websites. They're looking to see, did somebody make an improper transfer? You tried to deed your house away to your cousin Bob before you passed away, thinking that might avoid the mortgage claim. It doesn't. So there's nothing I can do about the mortgage. If you pass away and you have a mortgage, the house is either going to wind up being sold and we're going to pay it off. It's going to go into foreclosure and the bank's going to have it. That's it.
I want to speak to probate.
Mm-hmm.
You hear that it takes time, sometimes up to a year or two.
Yeah, I'd say it takes at least about a year.
Yeah, at least.
You have about 8 months for the creditor's claims. It's not a quick process. Also, if there are any, oh, I apologize, if there are any disputes whatsoever, if there are any issues whatsoever, it takes even more time. So, go ahead.
If you have property in other states, does that always have to go into probate in those states?
It does have to be probated in those individual states. You know, I don't know the rules in every state, but I know in South Carolina, if you have property, it has to be probated here. And essentially, what we could do is sort of similar to what I was talking about before. We could actually get the will approved up here, and then we could say, well, the will's approved up here, so now we just need to do a deed of distribution. But the cost is about the same. It's about just as time consuming. What the probate court prefers you to do in South Carolina is just open up an estate in South Carolina, get someone named as the PR, deal with the property up here. So.
And to deed it to somebody else?
Well, but if you're still alive and you still have capacity and it's paid off, you can always deed it to somebody else.
You can. If you're alive, you can deed something to anybody you want.
Anybody? Well, again, if is it paid? One, is it paid off? Two, do you have capacity?
Yeah.
Three, you may want to consider a life estate. So a life estate says you own it during your lifetime, with people who are going to inherit having a remainder interest.
One of those properties is in a life estate.
What's that?
One of those properties that I'm talking about is in a life estate.
Then I don't know that you will have an issue, because frankly, when you pass, so it's sort of similar to that joint right of survivorship. When you pass away, you're no longer on the deed, essentially.
Yes.
You're no longer with us.
Yes.
But individual states might want you to retitle it, and they might want to charge you a fee. I don't know why you would have to open up an estate in that situation. But I also don't know if New York and some of these places have decided. Yeah, they might say, hey, we figured out a way to charge $250 to do this. So, Chris, our other attorney's licensed up in New York. I know enough about New York to be dangerous, which is just to say that everything up there costs a heck of a lot more money. Things that we would consider somewhat simple down here are allegedly very time-consuming and expensive up there. Go ahead.
I always thought that you could put your house in a trust so that if you ever were to be sued, your house would be safe. Is that not right?
Well, you can put your house in a trust, and depending on the type of a trust, it may be that your house is safe, but generally it's an irrevocable trust. And I think that trusts are, our firm believes that trusts are oversold and underutilized. And the value of them is oversold to people. I make a lot more money selling you a trust than I do selling you a simple estate plan. What is the likelihood you're going to be sued? I mean, what are we worried about getting sued for? Do you run a small business?
No.
Do you have home?
No, I just always thought that.
Well, but if you put it in an irrevocable trust, it is possible. But the problem is it's irrevocable. Now you've lost control of your house. What happens if you wanted to say, want to liquidate it, or you want to do something like that? It creates a problem. You can't just, another thing you could do rather than put it in a trust is you could just put the property in an LLC, because then in theory in fact, most people I advised, if you have property you're investing in, set it up in an LLC, because at least then when you get sued, we got to pierce the corporate veil first, that's not nothing. It's not easy to do. And I don't have time to go through all the ways you can pierce the corporate veil, but essentially we got to pierce the corporate veil to get to you individually anyway. So the easiest thing to do is, rather than creating an irrevocable trust to protect your asset from being sued, put it in put it into an LLC. A lot of times irrevocable trusts are planned a long time in advance to create up situations where you potentially qualify for Medicaid. What if you have a special needs child? There's certain things you can do in advance, but whenever we hear the word irrevocable trust, we get worried. There are occasions where it makes sense, but it's not as often as people would think. And if you're just doing it because you're worried about some imaginary lawsuit, I don't think that makes sense. I would just put your property in an LLC. Go ahead.
Could you touch a little bit on gifting?
Gift.
While you're alive.
If you go to so the gift tax exemption right now is $5.49 million, which is the same as the federal state tax exemption. Basically, if you give over $14,000 a year, talk to your accountant. There are some forms you need to fill out to show that you've given. You're reducing your credit, so to speak.
Is that to one person, or would that be total gift?
My understanding, and I don't do a lot with the gift
Oh,
tax. Chris
okay.
does a lot more with that. But my understanding, it's actually, you have 5.49 million per, just in total. My understanding is the annual gift exclusion is $14,000, and I don't think you can just hand out a bunch of $14,000 gifts. But I may be wrong about that. You may be able to do that, and the question would be, does that come? I don't think so. It wouldn't make sense, but I'm not 100% on that. And a few years ago, we had talked about that. I just don't want to state that for certain. I could look into that. I don't want to state that for certain.
Okay, thank you.
It doesn't come up that much anymore. You're unlikely to. Again, when it used to be not even that long ago. Well, within my lifetime, the estate tax exemption was $500,000. I mean, when I got out of law school, when I started law school, it was like $1 million. It's gone up, and it used to be a higher tax. It's 40% on everything over the 5.49 million for individuals. I mean, this thing has gone up dramatically in the last 20 years. It wasn't keeping up with inflation. It wasn't fair the way it was being done before. But it's kind of like everything else. We go from one extreme to the next, and just can we find some common ground? There are some people that argue an estate tax is not a good thing, and there are a lot of people, and the argument behind it is they worry about small businesses, and there is an argument there. If your small business is employing a bunch of people and your small business is valued at $10 million, but without your small business, a bunch of people going out of business, and a bunch of people don't have jobs, it's probably not fair to impose a big tax on that small business when the beneficiaries are planning on keeping it alive. My own personal belief on the estate tax and that hypothetical I just provided to you, give the beneficiaries a credit if they keep the business alive. In other words, to me, the estate tax is the best tax out there because it's supposed to be a capitalist society. Everybody starts at the beginning at ground zero and they make their way. I'd rather have a lower income tax, a higher estate tax, but in that hypothetical situation, what you could do is give the beneficiaries a credit for keeping the business alive. Every year they keep the business alive, their tax is reduced. They don't owe it. So, it's just there were solutions for this problem that weren't presented by Congress. Let's put it that way. And I think we've reached the end. Does anybody else have any quick? We didn't get to Medicaid. I maybe got a little bit too aggressive about what I thought we were going to talk about, but.
Oh, thank you all for having me here. And my name is Bonnie Noble Silberman. I'm a licensed master level social worker and an aging life care manager. I don't know if you've ever heard of geriatric care management before, or ever heard the term. Well, the care management started, in the 90s, and I've had the privilege of being a part of the national organization of what has now been rebranded to Aging Life Care Professionals for the past 9 years. Anyways, I had a couple things in mind as Brian was talking, and I just wanted to say them right away. What he spoke about in terms of our life plans, our estate plans, our designating health care and financial powers of attorney is something that we, if we haven't done already, must do, and is really a gift to our children and the people that are in our family. I mean, my husband and I are in our mid-60s, and we've changed our will and our estate plan. We both have small businesses, and we've talked with our adult children about it and let them know what the passwords are to our accounts, where things are, so that they know. It was the hardest conversation to have, and my oldest daughter, who's 31, said, I don't want to know. I said, Becca, you got to know. God willing, we all hope that when it's time for us to turn the page and that we go peacefully and quietly, and that's it. But when it happens, at least to be able to give that gift to our kids so that they know what to do. My mother did that for me and my siblings. She had an advance directive, a living will. She gave it to us while she was alive and well. And when she became ill and was in the hospital, and they had her on life support, and it had been several successions of that, we had that plan. We knew what her wishes were. and we executed them, which is exactly what she wanted. And there was no, it actually was a beautiful thing to be able to know that I was honoring her at that time and at the end of her life. So anyways, I just wanted to say that. If we haven't done it, it's a gift. Do it. Wrap it up, put it give it for Christmas or Hanukkah or whatever. And there. Anyways, I have a private practice called Geriatric Resource Services. I also work as a home health social worker with NHC. But what I do in both worlds is help families and older adults kind of navigate the way. On the side, I facilitate a support group with June Green for the Alzheimer's Association. I also facilitate a support group for the Parkinson's Society. So I've been in this community now for 25 years and have never met a finer group of professionals that I've come across over the years that have served older adults and families, and I am truly honored to be a part of it. So I wanted just to tell you a little bit about what we do, how people utilize us, and take any questions that you may have. But I wanted to start off by saying this, that I heard it said that aging is a human experience, not a healthcare experience. And when I asked the person their intentions, what did you mean behind that statement? Her response was that oftentimes we miss the opportunity to look at aging as a developmental phase. Now, we all remember when our kids were little, we read, birth to 5 years. I had every book. I was at every chapter when my kids were going, they're here, they're at this. We always planned as we could for our children as they were developing. Well, I know that the person who said this line, aging is a human experience, not a healthcare experience, was speaking of that we really need to look at aging as a developmental phase also and to plan accordingly. And a lot of what Brian talked about was part of that planning. As I said earlier, those of us that are blessed with good health will take it from there until the end of our days, and those of us that are aging and not blessed with good health but are trying to manage it, we're going to try to do the very best we can. Why do people call on aging life care professionals? Where do we come into the picture? Well, there was actually, let me tell you a little bit about the organization itself. We've been around, as I said, since the 90s, and there are aging life care professionals throughout the United States. And when my mom was sick, I sought a colleague in Michigan to be the support that she needed, because I wasn't aware of the resources that were there that could have helped her have quality of life until the end of her days. The woman that started the practice that I'm in, Sally Gold, said to me when I first started, when I bought the practice from her, said, "You're like a professional daughter, Bonnie." And I said, well, and I really believe that now, because as a professional, I'm able to have an independent view to be able to help families identify what's going on through an assessment process, which is a conversation, getting to know who a person is and what their needs are, where the strengths are, where their challenges are, and then put together a plan of care that makes sense. The best way to really explain what I do is to give you some stories. So oftentimes I'll get a call from an adult child who may live out of state, whose mother or father lives here, and they're concerned that because of their compromised health, that they may need some advocacy, some support, boots on the ground, professional daughter, to be there if, God forbid, there's a medical event that would require, if they lived close by, they'd be right there. But if they're not living close by, they need somebody to go in their stead. So if I get a call from an adult son or daughter, what I then do is make contact with the parents or ask them, have you talked with your parents about what you want to do? And that you want to be able to engage someone like myself to help be there as a support. So we talk about, we set up an appointment, we schedule an interview, we have a conversation. I'm a social worker by profession. So my skill set is establishing rapport, developing trust, and really listening to what it is that person wants and needs and what's going on. If somebody calls me and they're in the middle of a crisis, I'm going to try my best to gather all that information. My very first case, I will tell you, almost 9 years ago, was I got a call from a daughter who worked actually an attorney's office. Her father had had a heart attack, and he was in the hospital. Her mom has dementia. She lived locally. But what she wasn't really aware of was that her dad was caring for her mom, and that she was far more disabled than daughter believed it to be true. And so suddenly dad's in the hospital. She's torn. She's an only child. She wants to be with dad in the hospital to find out what's going on. But mom needs somebody to be with her. Mom doesn't understand why dad's not there anymore because her level of dementia just was not in touch with the reality. So I met with the daughter actually in the hospital, in the emergency room, got as much information as I could. Then we made sure that her dad was set with they were admitting him and he was going to be well cared for. We then went over to her house. She had called in a neighbor to take care of her mom. I met with her mom, was able to assess what her needs were by just my observations, talking with her and getting information from the daughter. Then we were able to pull in an agency to come in and help provide some support for mom while daughter could be with her dad. And we were able to give her daughter peace of mind. She could be the daughter that she needed to be for both parents, knowing that they were both being well cared for, and she could split her time. I provided oversight for the agency that we put in place at her home for her mom, and I also helped her with advocating for her dad to make sure that following his hospital stay that he was going to be able to go into rehab and be able to get the supports that he needed. So sometimes just having that independent set of eyes and ears, that professional daughter, the key is the professional part, because the emotions, I've been there with my own parents, the emotion, I don't have to have those emotions. I can be empathic and understand what's going on and help you make informed decisions without the worry of a son or a daughter may have. Does that make sense? We've all been there. I can't. When my mom did not want me to hire a care manager on her behalf, she said, "That's what you did, Bonnie. You're a social worker. You're a care manager." And I said, "Yeah, but I'm your daughter first, and I can't." You know, it was just way too emotional for me. I wanted just to let you know a little bit about our Florida chapter. We have chapters all over the United States, and our Florida chapter is one of the biggest ones, believe it or not. And they did a study on the value of working with an aging life care professional. So I thought I'm going to tell you what this is because I thought it kind of validates all that I do. They basically said that 90% of the persons that hired us, so sometimes it could be the older adult, the person themselves or their family, whoever hired us, said that 90% had a positive overall effect on the person they were representing. 99% said that engaging an aging life care manager had a positive effect on their own lives because for them it provided peace of mind. Most respondents reported that they engaged us as professionals because, number one, the family did not live nearby and they needed a local contact for care, sort of like the example I'd given you earlier. They were concerned about the changes in their loved one's status. There were some things going on that they just weren't sure about, and they needed somebody to take a look-see. The person was experiencing a crisis at the time professional services were sought, like the example I just gave you with the gentleman in the hospital and the mom at home with dementia. Or they're just seeking a professional assessment to explore options for someone's care. All of those reasons together are reasons why people seek us out as professionals to help with advocacy, decision support, resources in the community. Sometimes it's just a consultation. They'll call, they'll want us to come over and talk with them. And well, I'm going to give you a perfect example. It's actually a family that was considering moving here. And they were living in a couple that had a single family home in a neighborhood. It's okay, Russ. You're excused. And they really wanted to have a conversation with me about the pros and cons. Not that I was giving them the pros and cons, but I was the listener in terms of staying in the home they were in or moving to a continuing care community like Rolling Green Village. And what was important. So we talked a lot about, they were value-based questions. What's important to you? What do you feel that you're missing? What do you feel that you have? You know, we just had a wonderful conversation for about an hour. And I followed up with them after that one-time consultation. And they had made a decision to go ahead and move, that it was time for them to go. And they did find a property here. So that was a nice thing for Rolling Green Village. So sometimes it's just a one-time consultation. Sometimes it's a consultation and then we create a plan of care like I've met with you, you may need some support in the home, you may be looking at options, you may need a referral to a specialist like a memory health specialist if there are some cognitive challenges. We can help. I can put some recommendations together after we talk and we decide, again, where are the challenges, where are the strengths. And then sometimes people will say to me, Bonnie, will you go ahead and make that call for me? Or could you go ahead and interview that person? Or I'll take this, thank you very much, if you could just help me with this piece. So when people engage our services, it's for as little or as much as they want. I feel like I'm rambling here and I had a whole outline, but I just wanted, our goal and our mission is really to help families and older adults kind of navigate the way and to really help people age well in the years that come and to provide opportunities and perspectives that may be overlooked or not seen, especially when you're in the middle of a crisis or a change in some type of functioning. Not everyone calls on an aging life care professional. We're not covered by insurance. Some long-term care insurance policies do cover, so it's concierge. It's tailored to your needs. I brought some brochures for you. We have a website which I encourage you to look at. It's got lots of tips and scenarios that may be of help to you. And as I said, before, aging is a human experience. We're all aging every day, and if we were to line ourselves up, even according to chronological, youngest to oldest or oldest to youngest, we all age differently, and we all manage things differently. It's all whatever our DNA is. We're all very different, and we really try to help get to know a person individually. It's my biggest joy in life to be able to get to know somebody, to work with a family, and to help also with some of the, Brian alluded to it in terms of the, there may be disagreements at the time of the will and so forth. Well, we're skilled social workers. We work with families. We understand dynamics. We can help kind of fare that out and provide mediation if needed. I work a lot with the probate court. I haven't worked with Brian, I don't think, but he may have worked with some of my colleagues where we do assessments for those people that are being petitioned for guardianship. So when he talked about incapacitated, he meant cognitively or mentally incapacitated, not physically incapacitated, people that aren't able to make decisions on their own. And so when that happens, and if someone is not already appointed as a health care or a fiduciary power of attorney, then they have to go through the probate court for guardianship or conservatorship. And the court, I do a lot of work with the judges here. We do evaluations for them, for folks that are being considered for guardianship. And we also, when there are no family members around, we have been called upon to be a professional health care power of attorney, where elder law attorneys have the person has hired us to be their healthcare power of attorney. And as somebody said to me when we just did one a few weeks ago when we were talking about it, she said, well, how will you know what to do? And I said, well, you're going to tell me. We're going to talk about that. What's important to you? Because that's what's going to be written in your living will. And so that if, God forbid, something should happen, we know exactly. Just like the gift we give our kids. They've just hired us because there's no other family members. And, there's been I've read a lot of articles lately about elder orphans, those of us that don't have family or children around. And so a care manager can play that role.
Is it appropriate for a person to contact you for themselves?
Oh, yeah.
And then go on to speak to their children?
Oh, absolutely. I get calls from, everybody. Individuals that have called us and have just wanted us to be their advocate, their responsible person, not in the way that the attorney was talking about it, but their first responder. I have a lady who called me who hired me many years ago, she's a widow and her children both live out of state, and we have an agreement, If there's something where she needs my support and advocacy, then I'm there at 4 o'clock in the morning, picking her up at the hospital or we're 24/7.
You didn't mention your fees.
We have an hourly rate of $125, and we bill in increments of time. So we're very, I'm a social worker. I'm a very good steward of a person's money. But more importantly, everything that we do is we've talked about it. You've asked us, or we've agreed to do A, B, and C. So nothing is done without our complete transparency. We bill on a monthly basis, and again, there's a service agreement, which is like just kind of explains our hourly rate, and then there's a release of information that we have people sign because, if we're having to interface with the physicians or a hospital, we want to make sure that they understand.
Bonnie, I know sometimes as PH, we may run into difficulty with writing checks
Yeah.
or balancing our checkbooks. Would that be something where you could put us into the contact with someone?
Yes.
Or would that be something you would do?
I do not handle anything fiduciary, no, but I do know someone who does that, who's wonderful, I'll just tell you this quick story. I was working with a lady who was in her mid-90s. She lived in an assisted living community. She was a lovely woman. She had macular degeneration, and for the years that she had been living in the assisted living, before I met her, the owner of the assisted living community was actually writing the check for her payment, her monthly payment. He did it as a good soul. When we got involved, he said, I know I shouldn't be doing this. This isn't right. She didn't have any children. No, her neighbors were the ones who introduced her to the assisted living, again, long before I got involved. So when I got involved and we talked, we did two things that were really important for her. We did, together we did the 5 wishes. I don't know if you've heard of that. That's another living will. We did that together. I read it to her line by line, one by one. We did it over a series of 3 days so that I could make sure I knew what she wanted because she didn't have any family. And then secondly, I referred her to a woman in town, Carrick Consulting, Amy Carrick. She does a lot of money management. Can write checks and take care of taxes and do it for you. She's wonderful. So those 2 things were put in place for Esther. And when she passed, I'll never forget this. The assisted living community administrator called me, of course, and her neighbors wanted to do a particular kind of service, and he said, but Bonnie, you and Esther wrote this thing. She wanted this hymn sound. She wanted this hymn to be played, and they were going to choose another one. I said, well, we're honoring Esther. We're going to play the hymn that she wants to hear, and it was just a beautiful thing. So it's late. It's 4:30.
I placed your brochure.
Oh yeah, I left some brochures. If we have a pretty thorough website, you can take a look at it, and if we can help you in any way, let us know. Thank you for having me come.
Thank you.